The first question is when do you have an obligation to preserve? And the court has clearly said that if you have this distinct possibility of litigation, you have a duty to preserve evidence. And then the next question is, all right, who has to preserve it? I'm John Walsh, past president of the State Bar, 1989. I'm with the firm of Axley Brynelson in Madison. This morning I was presenting a program on spoliation of evidence, the destruction of evidence. Spoliation meaning alteration, destruction, and even concealment of evidence. In the last number of years, I've just seen an increasing number of cases where there's destruction or the evidence has disappeared, somebody claims they can't find it. The first question is when do you have an obligation to preserve? And the court has clearly said that if you have this distinct possibility of litigation, you have a duty to preserve evidence. And then the next question is, all right, who has to preserve it? Well, clearly the client, and the lawyer has to advise the client. At the same time, the lawyer that retains an expert to evaluate the product or the appliance or whatever it is, the expert has a duty to preserve it, can't engage in any destructive testing without the other side having an opportunity to see it, know it. And then the lawyer has a certain duty. Sometimes plaintiff's lawyers, appropriately, will take control of a particular product so that it is preserved. But the lawyer working with the expert, the lawyer also has a duty to make sure the expert and the client preserve that evidence. Clients often call, and you get an unexpected call where a client says, this happened. All right, could be a workers' comp, somebody injured on the job. It could be a contract that didn't work out. It could be one of their people are injured or one of their drivers injured someone else. So they call you up and say, now, what should I do? Or we typically say, well, report it to your insurance company, but at the same time, we also have a duty to explain to the client if there's evidence that's involved, and because there's a potential for litigation, the client has to be advised as to how to preserve the evidence. Business clients, for example, hospitals, bigger institutions, insurance industry, they all have a document destruction policy. At a certain point in time, they routinely destroy. Well, they can't routinely destroy documents or evidence if there's a possibility of litigation. So then a lawyer either has to alert the people in the company, in-house counsel can, but somehow people have to be told, for this product or for this project, do not destroy evidence. I think it's going to be an issue. I think we're going to see more and more cases of it. Sometimes it's because people just aren't aware of the obligation to preserve it. Other times, I think there's an effort to, we made a mistake, let's fix the problem, let's get rid of some of these records. Sometimes it's in good faith, a mistake. Other times there's a number of cases out there, including Wisconsin, where intentional destruction has occurred, and the courts have to deal with it and figure out what the appropriate sanction is.